Welcome back to the Montgomery Deep History Podcast. I'm going to say something before we begin that I want you to hold on to for the entire length of this episode. This episode is being recorded May 11, 2026, and on May 11, 2026, the Supreme Court of the United States issued a ruling in Allen v. Castor that changes the landscape of everything we are about to discuss. I'll explain the ruling in full before we close, but I want you to know from the first moment that you're not listening to history that has settled. You're listening to history as it is being made. I also want to say something up front that I think some listeners need to hear clearly. Black people have not lost their right to vote. What is at stake in these cases is whether the drawing of district lines dilutes the voting strength of Black Alabamians under the Voting Rights Act. That is a serious legal and political question, but it's a different question from voting rights in the most fundamental sense, and I want that distinction to be clear from the start. I'm going to anchor this episode in primary documents, court opinions, and filings, and then I'll reference reporting across outlets. When I quote an elected official, I'll say so. When I quote an opinion piece or an advocacy organization, I'll label it. And when I describe what people mean by phrases like gutted, for example, I'll attribute that as a viewpoint, not a legal finding. Moving on to redistricting in plain language. Just to reassure everyone listening, this is a matter of redistricting, which in this case involves legal disputes over whether new district lines would dilute the voting strength of Black Alabamians, as we noted earlier. And that's different from losing the right to vote, but it's still a serious question of political representation under the Voting Rights Act. Redistricting is the process of drawing district lines for Congress and for state legislatures. It usually happens after the census, but it can also happen mid-decade when courts block a map, when lawmakers pass a replacement, or when election timelines force quick decisions. In many modern cases, the legal tool at the center is the Voting Rights Act, especially Section 2, which is used to challenge maps that allegedly reduce minority voters' opportunity to elect candidates of their choice, compared to reasonable alternatives given local demographics and voting patterns. Now, courts often analyze Section 2 vote dilution claims using the framework from Thornburg v. Gingles. You'll see the Gingles factor referenced repeatedly in the Alabama filings, and that's linked in the show notes. Before we go further, we need a clear distinction. Political or partisan gerrymandering means drawing districts to advantage a political party. Under current Supreme Court doctrine, partisan gerrymandering claims are generally treated as matters federal courts cannot resolve under the U.S. Constitution. Some states still regulate partisan gerrymandering through state or constitution or statutes. Federally, it's largely outside the reach of the courts. On the other hand, racial gerrymandering is different. If race predominates in drawing district lines without sufficient legal justification, that in and of itself can violate the Equal Protection Clause. Now, here's the nuance. Race can be considered in some circumstances, especially when a state argues it is trying to comply with the Voting Rights Act. Courts scrutinize how and why race was used and whether the use is justified under the law. That distinction between partisan motivation and racial motivation is the central legal dispute in Alabama right now, and we'll come back to that. So when we go back as early as 2013, I think there's some verbiage that we need to deal with that is quite relevant since we're talking about all these different things. So that brings us to Section 5, Shelby, and the quote-unquote still needed verbiage that is used. You'll actually see that used in a number of these cases. So to understand why people argue about whether parts of the Voting Rights Act are still needed, it helps to look at the debates around Section 5, preclearance, before Shelby County v. Holder. a number of you are probably quite familiar with that particular case. In the Department of Justice merits brief in that case, the federal government responded to the argument that Section 5 was no longer necessary because the proportion of objections had declined over time. You have to pay attention to that. So the brief, let's actually read a little bit of the brief. The brief actually states, and I quote, "Petitioner argues that Section 5 is no longer needed because the proportion of objections as compared to the number of submitted changes has diminished over time. But petitioner's statistical analysis paints a materially incomplete picture. Over the years, covered jurisdictions have made an ever-increasing number of submissions for preclearance. What is particularly important, however, is the number of discriminatory voting changes that were blocked by Section 5, and that number has not significantly decreased over time," end quote. The brief also notes that not every objection represents a finding of unconstitutional discrimination. Even so, the argument shows the tension that existed before Shelby. One side arguing that conditions had improved enough to reduce the need for federal oversight, and the other arguing that the volume and significance of blocked changes showed ongoing need. After Shelby, Section 5's coverage formula was struck down and the pre-clearance system changed dramatically. The shift is one reason people watch later Voting Rights Act cases closely, because the court's approach can reshape how the law functions in practice. This causes us to migrate from the Shelby v. Holder case to Louisiana v. Callais, 2026, what the court says it's doing. Now, to the 2026 Supreme Court decision tied to Louisiana's congressional map, Louisiana v. Callais, the primary source is the court's opinion, linked in the show notes as well. Justice Alito's majority opinion opens with a statement that sets the court's central concern about Section 2. So notice that we move from Section 5 to now Section 2. So I'm going to read a little snippet of this opinion as well. The opinion says, and I quote, "Section 2 of the Voting Rights Act of 1965 was designated to enforce the Constitution, not collide with it. Unfortunately, lower courts have sometimes applied this court's Section 2 precedents in a way that forces states to engage in the very race-based discrimination that the Constitution forbids." That is the court's stated concern, that some applications of Section 2, as interpreted by lower courts, can pressure states into race-based decision making that raises constitutional problems. So you see what's kind of popping up on the other end. So the court signaled two things at once: that it believes some lower courts' application of Section 2 had gone too far, but that it was not formally overruling Allen v. Milligan. That tension would become the fault line in Alabama cases decided just 12 days later. So that brings us back to Alabama and the congressional litigation, Allen v. Castor and the remedial fight. Alabama has been at the center of modern redistricting litigation. A public timeline is maintained by the Alabama Redistricting Project for Allen v. Castor, and that's linked in the show notes. One filing, hosted by the Democracy Docket, comes from Castor et al. V. Allen, number 23-12923. It's an opposition to a time-sensitive motion for a stay pending appeal. This document is written from the plaintiff's perspective, and it argues that Alabama's remedial plan did not fully cure what courts found to be a likely Section 2 violation, and that delaying relief would cause ongoing harm. Now, even if, let's say you didn't read every page, it illustrates how these cases often become fights over timing. That fight over timing especially became like a pressing point, I would say, on May 11th, 8 days before the primary. Now let's build on this just a little bit more. Since we're camping out on Section 2, just want to add a little more context to it regarding Alabama State Senate litigation. Stone v. Allen is one that I would like to bring up. So the redistricting litigation in Alabama isn't only about Congress, it also covers state legislative maps. In Stone v. Allen, a federal court order, which was dated September 24th, 2024, it denied the Secretary of the State's motion for partial summary judgment. The court emphasized that Section 2 cases are fact-intensive and often not suitable for summary judgment when disputes require weighing evidence and credibility. The order also addresses standing issues related to Huntsville area claims and concludes that the Alabama State Conference of the NAACP had associational standing based on an identified member in Huntsville. Now let's talk about this special segment, this special session that occurred not that long ago from Governor Kay Ivey, what it is, and also what I think it'll be great to bring in some thoughts and some words from Representative Chris England from Tuscaloosa. What he says it's not. In his May 2nd Facebook post, Representative England addresses what he describes as misinformation about what the special session will actually accomplish. Here are his key points because, we're just backtracking just a little bit to play catch up. 1, the Supreme Court must act for anything done in the special session to matter this cycle because Alabama has been enjoined from passing new congressional maps until 2030. And state officials have asked courts to lift or expedite that injunction. 2, this is his next point that he made. If injunctions are lifted, Alabama would revert to the 2023 Livingston congressional map and the 2021 state Senate map. 3, no new maps will be passed during the session. The tentative plan is to address 2 bills that would reschedule primaries to buy time. 4, he warned in his social media posts about practical effects for voters and candidates, including absentee ballots in affected districts. 5, reverting to the Livingston 2023 congressional map would eliminate the current configuration of the 2nd district and substantially after the 7th. So those were some of his major points. Now, as of May 11th, the Supreme Court has now vacated the injunction Representative England referenced. The 2023 map he warned about is now cleared for use pending further lower court review. Now, after the special session, it triggered a number of different things, protests, rallies, and whatnot. So the Montgomery rally and D-Day and what was reported, I just kind of want to get into just a little bit of what was going on during some of these rallies, some of the protests, and also some stuff that had occurred in the Alabama State House. Now, I did not personally witness the events at the Alabama State House, so I'm relying on published reporting, and I want to be clear about what the sources say and how they, just how they're framed. The week of the special session saw a sustained protest presence at the State House beginning May 4th. And the numbers can get up to about multiple hundred people who were at these rallies. Now, by Friday, May 8th, things had escalated significantly inside the chamber itself. According to some reporting, which is why there are some articles that are entitled D-Day. Deanna D. Reed, she is the Alabama State Organizing Manager for Black Voters Matter, and that's an organization founded by Cliff Albright, April Albright, and also Latasha Brown. She was in the upstairs gallery of the House chamber when protesters began voicing opposition to SB1, Bill SB1. The gallery is sealed off from the floor below by glass. Now, the timing here matters. Representative Chris England was just about to take the podium to outline his party's legal opposition to SB1 when the protests erupted above him. The House went into recess. And that just shows the nature of just kind of what was going on upstairs, downstairs, and all around. Now, AL.com ran an opinion column about that moment by Roy S. Johnson, and is labeled clearly as an opinion piece written from a particular perspective. Johnson describes Reed, D. Reed, as a friend and a fellow church member, so that relationship should be understood as context from his account, from his perspective. But his column contains direct quotes and on-the-ground detail worth bringing in. Johnson writes that Reed rose from her seat and began chanting, from his perspective, in the tradition of lunch counter sit-ins and other tactics from the civil rights era. He quotes Reed directly, quote, "I could have just sat there. That's okay for all people who did. I decided to disrupt in a way that now makes Republicans uncomfortable because they're making us uncomfortable," end quote. According to both Johnson's column and the Reflector's reporting, an order was issued to remove Reed from the gallery. As security personnel pulled her, she went to her knees and then to the floor. Several House Democrats rushed upstairs, including Representative Wandolyn Given, Mary Moore, Ontario Tillman, Kelvin Datcher, Neil Rafferty, and Travis Hendricks, who was also a sergeant with the Birmingham Police Department. Representative Gavon's account, as quoted by Johnson, is striking. She said, quote, "I never imagined I'd walk in and see this educated black girl pinned to the ground with her hands behind her back. You know I'm a tough cookie, but I'm still at a loss for words. I never thought I'd see this in 2026, end quote. Johnson also quotes Gavon saying, "The scene made her think of George Floyd." Now to focus on Representative Hendricks, drawing on his law enforcement background, said he stepped in, and this is a little quote as reported, not to escalate the situation, but to protect Dee's safety and prevent further harm. And he told Reed, "I got you." Now, Reed was removed from the gallery. She wasn't arrested, though. Johnson writes that she was carried out singing "We Shall Overcome" with her fist raised. Hours later, Reed told Johnson, "Today was not a defeat, but a defining moment. For me, it was about stretching out literally and figuratively. That's what we have to do in this season," end quote. After debate resumed, Representative England addressed the chamber. According to the Reflector, he said, "This is the people's house, and we are discussing issues that are serious. People will get emotional when we are talking about representation and engaging in fights we thought we already dealt with," end quote. Later that Friday, there was a rally outside the State House. Johnson's column is where the D-Day framing originates. Reed called people to the podium from Birmingham, Mobile, Huntsville, Talladega, and Eufaula, and she closed with the statement, "The people united will never be defeated." What's interesting is how that same day ended. Governor Ivey signed both HB1 and SB1 into law. 3 days later, the Supreme Court handed Alabama everything it had been asking for. If you want to experience this history in person, you can book the From Bondage to Freedom tour at montgomerydeephistory.com/our-tours. If you got questions before you book, email montgomerydeephistorytours@gmail.com. So what is the tour about? The tour isn't about trivia. It's not a fun facts kind of thing. It's about seeing how history sits in a place, how decisions turn into streets, buildings, neighborhoods, and institutions. It's designed to help you connect the dots across time and leave with a clearer understanding of what freedom required, what it cost, and what it still demands. If you're the kind of person who wants to leave Montgomery with more than photos, if you want understanding, this is for you. Now, there is another individual who I find would be fitting to bring in, and that's Mr. Earl Hilliard. And we'll talk about his perspective regarding recent happenings. Now, to understand what's actually at stake in these maps, it'll be better, I think, to hear from a man whose election made the modern version of this fight possible in the first place. And just to kind of give a historical note for listeners, before Mr. Earl Hilliard, the last black Alabamian to serve in Congress was Benjamin Sterling Turner, a man born into slavery in North Carolina in 1825. He was brought to Selma as a child, and he secretly taught himself to read. He built a business, and in 1870 won election to the 42nd United States Congress. Turner served from March 4th, 1871 to March 3rd, 1873, representing Alabama's 1st congressional district. After Turner's single term, no black Alabamian would serve in Congress again for 119 years until Earl Hilliard won in 1992. That gap, 119 years, is the length of the silence that redistricting helped end. As of May 11, 2026, the districts that ended that silence are in legal jeopardy all over again. And Earl Hilliard is now 84 years old. He was a student at Morehouse College in Atlanta during the Civil Rights Movement, organizing along figures including Martin Luther King Jr., Julian Bond, and Jim Clyburn, now a congressman from South Carolina. He told AL.com's Joseph D. Bryant that Dr. King's words shaped his path. Dr. King informed him, "You've got to come out of the street because we're going to need you in the courthouses, in the legislatures, and in the White House. We're going to need mayors. We're going to need city councilmen. But before we even need them, we're going to need lawyers." As a result, Hilliard went to law school. In 1992, redistricting after the 1990 census created a new majority black congressional district, the 7th, stretching from Birmingham through Selma to Montgomery, through the heart of the Black Belt and the old battlegrounds of the Civil Rights Movement. Hilliard won that seat, becoming the first black Alabamian in Congress since Reconstruction. He held it for a decade. That same District 7, now held by Representative Terry Sewell, is one of the 2 seats that Alabama's current redistricting push would dismantle. The other is District 2, redrawn by a federal court order to create what the court called an opportunity district with a nearly 49% black voting age population. Representative Shamar Figures won that seat in 2024. Hilliard's argument, as reported by Bryant, is this: Republicans cannot eliminate majority black districts without scattering black and Democratic voters into previously Republican-leaning areas, and those areas have changed. He said they want to get rid of the Democrats in Alabama. The problem is they won't be able to succeed. They cannot get rid of black Democrats without creating white Democratic districts. And he pointed specifically to Tuscaloosa, Birmingham, and the growth of black suburban voters in Jefferson County and Shelby counties. Mr. Hilliard further noted, "So now you can't isolate Birmingham and think you're isolating all the blacks. The water is over the dam." Pause for a moment to note clearly that state Republican leaders dispute the framing that their moves are race-based, describing their actions as party-based political line drawing, which under current federal doctrine is constitutionally permissible. That dispute is precisely what the courts will now revisit on remand. Hilliard closed with the kind of long view that comes from living through 119 years of history compressed into one lifetime, and he said, "The pendulum swings because people are always trying to get to the middle. I want African American representation in Congress, but if I can't have it, I want a Democrat, and I know that as they configure these districts, we're going to get some Democrats, end quote. So let's focus on the bills from the special session, HB1 and SB1, and just kind of look at how they are directly relevant in a way that they were not before the May 11th ruling. And so HB1 authorizes a new special primary election for affected congressional districts if a federal court ruling allows Alabama to use its previously enacted congressional plan, Act 2023-563. The August 26, 2026 certification deadline applies, and the bill eliminates a runoff for that special primary. SB1, on the other hand, mirrors HB1 for the state Senate districts under Act 2021-558 with the same certification deadline. With the Supreme Court's May 11th order now vacating the injunction, the mechanism in HB1 may be activated. Whether it actually triggers depends on how quickly the lower courts act on remand when it's sent to the lower courts, and whether any new orders are issued before May 19th primary. CBS News, publishing Associated Press reporting, situates Alabama's actions within a broader regional response following Louisiana v. Callais. Tennessee has also enacted a new congressional map that carves up a majority black district in Memphis, also in the middle of protests and litigation. So let's deal with the May 11th Supreme Court ruling. Allen v. Castor, Allen v. Singleton, Allen v. Milligan. Now I want to walk you through what the Supreme Court actually did today, because the order is short, but its consequences are significant. The primary document is linked in the show notes. Make sure you take a look at that. In an unsigned one-paragraph order, meaning the court did not identify which justices were in the majority and offered no explanation, the Supreme Court took three actions. First, it granted Alabama's motion to expedite. Second, it granted Alabama's petition for certiorari before judgment in Allen v. Castor, meaning it agreed to hear the appeal before the full appellate process was complete. Third, it vacated the district court's judgment in all three cases, Allen v. Castor, Allen v. Singleton, and Allen v. Milligan, and remanded them to the lower courts for reconsideration in light of Louisiana v. Callais. And the word vacated is the operative word. The permanent injunction blocking Alabama's 2023 redistricting plan, the one that found intentional racial discrimination after like an 11-day trial, 51 witnesses and nearly 800 exhibits, is now vacated. The 2023 map is cleared for use while the lower courts reconsider. Justice Sotomayor dissented, joined by Justices Kagan and Jackson. Her dissent, which is shown in the show notes, makes three arguments worth understanding. And I think we definitely need to look into these. She argues there was no reason to vacate because the district court's ruling rested not only on Section 2. You see how we're circling back around to Section 2 of the Voting Rights Act, which Callais addressed, but also on the 14th Amendment's prohibition on intentional racial discrimination. That constitutional finding, she writes, is independent of anything in Callais, and Callais did not address it. Second, she argues that even if the court felt compelled to act, the timing was wrong. The primary election is next week. Overseas ballots have already been sent in even. She writes that vacating the injunction will immediately replace the current map with Alabama's 2023 redistricting plan until the district court acts, even though voting has already begun. And third, she notes that the district courts remain free on remand to decide whether Callais has any bearing on its 14th Amendment analysis, leaving open the possibility that on remand, the lower court reinstates its findings under a different legal theory. The majority 6 justices did not respond to any of these arguments in writing. The order contains no explanation. SCOTUS blog's reporter Amy Howe reported on May 11th that the court's action clears the way for Alabama to use the 2023 congressional map that a lower court had blocked as racially discriminatory. That is a factual description of what happened. Whether it is the right outcome is a legal and moral question that I will leave to you, the listener, to the court's own remand, and to history. So just hours after the ruling, Montgomery Mayor Stephen L. Reed, the first black mayor in Montgomery's history, issued a public statement on behalf of the city of Montgomery. I want to read it in full, and this is attributed to him as an elected official giving a public statement. And he says, and I quote, "Today's Supreme Court decision is deeply disappointing and represents another troubling step backward for voting rights. For generations, Alabamians, especially black Alabamians, have had to fight to ensure their voices were fully recognized in the democratic process. Voting rights were marched for in the streets of Montgomery and Selma. People bled for them. Some died for them. Decisions involving representation and voting access strike at the core whether every community has a fair opportunity to be heard. At a time when public trust in institutions is already strained, we should be working to strengthen confidence in our democracy, not weaken it. Progress is rarely permanent unless people are willing to protect it. History shows that when people organize, participate, and refuse to be silenced, progress remains possible. Montgomery will continue to stand on the side of civic participation, equal representation, and the principle that every voice deserves to be heard." End quote. That statement was posted on the City of Montgomery's official social media on May 11, 2026. That link is also in the show notes. I want to sit with one line from Mayor Reed's statement for a moment, because it is exactly the kind of thing this podcast exists to contextualize. And that's the line where he says, "Voting rights were marched for in the streets of Montgomery and Selma. People bled for them. Some died for them." End quote. That's not rhetoric. That is history. And it is happening on the same streets where I give tours. That's why this episode exists. Segment 12. And so some may not understand the bearing upon this situation from another document from some time ago. I just want to add one more layer of context here. It's the document called Mandate for Leadership, the Conservative Promise, published in 2023 by the Heritage Foundation as part of Project 2025. I want to be precise. It does not explicitly call for gerrymandering or for drawing district lines to advantage Republicans. What it does contain are policy recommendations that will reshape the upstream conditions that redistricting depends on: who gets counted, who oversees enforcement, and how data gets collected. First, the citizenship question on the census. The document states that, quote, "Any successful conservative administration must include a citizenship question in the census," end quote. This directly affects apportionment, how congressional seats are divided. The connection to redistricting is well established in the legal literature. Second, control of race and ethnicity data. The Mandate for Leadership document also calls for a conservative administration to take control of how race and ethnicity are categorized in the census, expressing concern that proposals could be skewed to bolster progressive political agendas. Section 2 litigation depends on this data. Third, defunding and redirecting the Civil Rights Division. The document calls for reorganizing the DOJ's Civil Rights Division. which is the office that enforces the Voting Rights Act, including Section 2. Critics argue this reduces the federal enforcement capacity that has been the primary check on discriminatory redistricting. Fourth, census partnership strategy. The Project 2025 document acknowledges that in 2020, lack of conservative participation was one factor in an undercount in some areas affecting representation. It frames census participation explicitly in terms of consequences for apportionment. Project 2025 is not a redistricting plan, but it describes policy changes that would alter the terrain on which redistricting fights are won or lost. The document is linked in the show notes as well. Now let's turn our attention briefly as we near our close to some words that I think we need to pay attention. Still needed and gutted. So you'll hear people say the Voting Rights Act is being gutted. That phrase is not a legal term. It's the way some critics describe a pattern they see. Over time, major cases affect different parts of the act and the practical reach of the law changes. Supporters of the court's approach describe these decisions differently, as enforcing constitutional limits and preventing race from being used in ways the Constitution forbids. The most careful way to navigate this is to separate three things. 1, what the statute says. 2, what the court says it is doing. 3, what different commentators believe the consequences will be. Today's ruling in Allen v. Castor is a fresh data point in that debate. How you categorize it depends on which of those three lenses you apply. One more piece of context comes from way back in 2023 KSAT report entitled "A Supreme Court Redistricting Ruling Gave Hope to Black Voters. They're Still Waiting for New Maps." Now that was a title from that particular news outlet, KSAT. That story was about the gap between a major court ruling and what happens next on the ground. As of today, May 11, 2026, that theme has a sharp new edge. The gap between hope and implementation is now again wide open. And as Earl Hilliard's story reminds us, sometimes that gap is measured not in months, but in generations. Remember, it was 119 years between Benjamin Sterling Turner and Earl Hilliard. History does not move in a straight line. So, where do things stand right now? Let me tell you exactly where things stand as of this episode's recording, May 11, 2026. The Supreme Court of the United States has vacated the permanent injunction that protected Alabama's court-drawn congressional map. The 2023 redistricting plan, which a federal district court found after an 11-day trial to be an intentional effort to dilute black voting strength in violation of both the Voting Rights Act and the 14th Amendment, is now cleared for use while lower courts reconsider. 3 justices dissented. The majority offered no explanation. Montgomery's mayor has called the decision deeply disappointing and a step backward for voting rights. D. Reed was carried out of the State House gallery 3 days ago, singing. Representative Chris England stood at the podium of the People's House and reminded his colleagues what is actually at stake. The May 19th primary is 8 days away. Overseas ballots have already been sent. The special primary mechanism in HB1 and SB1 may now activate. The lower courts will receive the case back and decide, potentially for the 3rd time, whether Alabama's maps are constitutional. Psst, here's what to watch immediately. How do election administrators respond to the vacater when something that means so much to so many people has been set aside? What happens to the May 19th primary? On remand, does the district court's 14th Amendment finding survive reconsideration? That may be the most important legal question remaining, and this is dealing with the intentional discrimination finding that Justice Sotomayor says Callais does not touch. The next thing to watch. By August 26th, does the HB1 special primary mechanism activate, and can it be executed on that compressed timeline? And lastly, on the horizon, how do the upstream changes described in Project 2025 on census methodology, enforcement, and data interact with the redistricting fights still to come? So, all sources are linked in the show notes so you can read the primary documents yourself and compare reporting across outlets. This is exciting and sobering at the same time, which is exactly what honest history feels like when you're standing in the middle of it. I'm Keelan Adams, a local historian and tour guide for Montgomery, Alabama. And right now, Montgomery is the center of the story. This is Montgomery Deep History, where we tell a deeper story.